Welcome, everybody. My name is Rose Kervick. I'm a director with Accountant Online, and I'm joined by Alan Ryan this morning from Wallace Corporate Counsel. We're going to talk about the stage of when you've finished your term sheet, when you're raising money, and you're moving on to the next stage. So we're going to cover really what type of typical structure, whether it's friends and family versus angel, Enterprise Ireland, or venture capital. And Alan will talk us through the legal processes that we need to expect at this stage. And Michael Bambrick also, you're very welcome.
Morning.
So anybody wanting to kind of ask us questions throughout the course of the next hour or so, just drop your questions into the chat and we'll put them to Alan and Michael, and we'll begin. So Alan, if you'd like to kick us off.
Thanks, Rose. Hello, everybody. Look, I guess this is kind of a bit of a follow-on from our previous webinar on the execution of term sheets and some key matters relating to term sheets. But it's really now that the fun and games begin, insofar as the term sheet, when signed, save for the terms such as costs and confidentiality and exclusivity, save for those terms, they're not binding. So post-term sheet execution is where we get onto a more formal legal process. And it's not until such time as the formal legal process is completed and the legal documents are executed and funds are actually transferred that the actual funding round is formally complete and binding. So what we hope to do here is just kind of run through typical legal structures and ancillary matters relating thereto. We'll start off with kind of the more informal type funding round. So from friends and family onto angel, then a bit more formal onto the likes of family offices, Enterprise Ireland, and onto VCs. We'll touch on those as well. Mm-hmm. The fundamentals are the same regardless of the transaction or investment type. It's the level of formality that typically changes, and the formality, the friends and family round would be more informal because it's typically smaller investment size, lower valuation. Parties can rely on their existing personal relationships, the level of trust that's there already, to kind of take more of a more relaxed view regarding investment. So look, if some of this was touched on previously, but just to go over the basics here, friends and family round is essentially a small funding round from friends, family, personal connections that are generous enough to maybe look at an investment in a company early stage to maybe get the company off the ground, initial seed capital. Funding size for friends and family raise varies from 10, 20, 50,000 up to about 100,000 or thereabouts. Typically, the investment model or the investment documents are relatively light touch insofar as there be a short form term sheet, and the legal documents would relate to maybe an investment letter or a short form share subscription agreement invariably. Moving on to angel investors. Angel investor structure would, post execution of term sheet, would typically involve their legal counsel reaching out as part of due diligence initially, but their legal counsel will be advised they would have a fairly well-trodden path regarding their preferred commercial or legal terms to be included in the documents. The documents would typically emanate from their lawyers, come across to the company's legal counsel for review. And again, they'd be slightly more detailed depending on investment quantum and valuation size and stage that the company's at. Family offices are typically maybe a bundle or a group of angel investors that pool together under one umbrella, the likes of, say, Elkstone that operates in the Irish investment circles. Their typical investment size would range from anything from circa 100,000 up to 750K, and that's slightly beyond the friends and family raise, but it's still pre-seed or seed stage. Moving on to Enterprise Ireland, Enterprise Ireland's investment model or legal structure is slightly different insofar as Enterprise Ireland has, given it its kind of broad portfolio of investments in Ireland, they have a level of symmetry or uniformity across their investments and their investee companies. So typically what they do is, and maybe a few participants on the call here have gone through the process or in the middle of making an application to Enterprise Ireland for funding, but the applications are made online. You fill out the relevant DI questionnaires. Then if an applicant is successful, Enterprise Ireland will issue their term sheet together with their standard legal documents. And that's the same regardless of whether the investment is by way of Enterprise Ireland's competitive start fund, which we touched on previously is the 2 tranches of 25k investment for 10% of the company, or it's the same if it's a HPSU investment, which is further on. So that's typically Enterprise Ireland's match fund, well, Enterprise Ireland's high potential startup program, whereby Enterprise Ireland will invest on the basis that the company receives match funding. It's a bit further on in the company's life cycle, but CSF would be the starting point, HPSU would be the follow-on. Onto VC investments. Again, same fundamentals apply. There will be a more detailed term sheet and more negotiation on the term sheet as part of that process. The term sheet itself, again, would be non-binding, save for cost exclusivity and governing law. Typically speaking, VCs will have a very well settled term sheet framework within which they're willing to negotiate. And as such, that trickles then into the structure of the legals, depending on whether they're investing by way of shares, share subscription, or loan note subscription. They will have a very well settled process and step it out and give clarity to each of their investee companies at the outset. But key, say, from angel, family offices and VCs is the due diligence process, which we'll move on to now, which is essentially the investors doing their homework or background checks on the company. And that's not just legal due diligence, there's various different heads of due diligence, which I'll pass you over to Michael to discuss.
Great.
Yeah. Thanks, Alan. So essentially, you'll have pitched the company, the business, the idea, the technology to the investor in order to get them interested in investing. You'll then get to the term sheet stage where you'll agree the commercials. And once you've signed the term sheet, then the investors will want to know, I suppose, that what you've given them is accurate, the information that you've provided. And they'll also want to know in greater detail as well, what the projections are, what they're based on, detailed review of the business plan. It really depends on the size of the investment, the stage of the company, and the type of the investor. So friends and family, for example, it's probably early stage, there's probably trust there already. It's probably a lighter due diligence process. It might even be just a couple of emails, depending on how early stage it is. Once you get further down the track and it's venture capital, you've probably been in business a bit longer, you've more customers, more suppliers, more IP. The value of the investment is higher, the valuation of the company is higher. So due diligence is deeper and will take that little bit longer just to make sure that all the information that's been provided is accurate. And essentially what they're trying to do is just get comfortable with the investment and minimize the riskiness of the investment. If it's a VC, they'll probably issue a questionnaire which will set out their standard queries that they have, that they issue to every company that they're looking at. And you'll fill that in probably with guidance from your solicitor or your accountant or another relevant person who's assisted you on a particular part of the business. It tends to cover a few different areas, such as commercial, which might be market demand, your customers, your suppliers. Financial then will cover your accounts, taxes, your revenues, your projections. The team they'll also want to look at. They'll want to see if you've got domain experience or exactly who's involved, what their background is. Also, if there's any gaps in the team that need to maybe be filled now with a key hire or further down the line. They'll look at technical due diligence as well. So for example, if it's software, they will want to analyze and evaluate it. And they'll also look at legal due diligence as well. So they'll want to see the documents that are in place, say with your employees or your service providers, anyone who's creating IP, obviously, to make sure that that's assigned to the company. And they'll want to see the structure of previous investments, if there are any, or what rights people have, if there's a shareholders agreement in place. Once you're getting, I suppose, towards the end of due diligence, the investor should have a good idea of whether or not they're going to go ahead with the investment. And that's then when you'll start the drafting phase of the substantive documents, the shareholders agreements, the investment agreements, which Alan will take you through now.
Right. Thanks, Michael. Look, the principal legal transaction documents are largely driven by what's agreed at term sheet stage. So the term sheet, as touched on before, is a summary of key terms, but then those key terms are both reflected and fleshed out in the legal documents themselves. If we use an example of a friends and family raise, as I said before, they're typically lighter touch. So with that, the legals or the transaction documents are typically shorter form. What you might have is a short form subscription letter or investment letter, which would just deal with the conditions relating to the investment, the amount of shares to be subscribed for, the valuation, and any other agreed commercial terms or agreed legal terms. And it would put them on a formal footing once executed and once funds are transferred and completion occurs. We touched on before about the differences between, let's say, a share subscription and a convertible loan note subscription. Essentially, from a legal perspective, both modes of investment will entail a subscription or a form of subscription agreement, be it a subscription for shares or a subscription for loan notes. They'll both entail a form of shareholders agreement, which governs corporate governance, restricted transactions, just general business governance. The convertible loan note round would slightly different. The legal documents required for a convertible loan note raise slightly different so far as an investor subscribes for loan notes pursuant to a loan note instrument. And that instrument itself will detail the interest coupon to apply to the loan notes, the maturity date, and the conversion terms, i.e. the terms of which the loan would convert into shares based on a future conversion event. So essentially, the legal steps and the legal documents are very similar regardless of what route you go, but the legals are very much determined by what's agreed at term sheet stage. So it kind of brings us back to before that it's very important that term sheets are specifically negotiated, that you kind of enter into them with your eyes open, because it's very difficult to reverse negotiate after the term sheet has been signed. The term sheet is a key term document on which the investor is willing to do business. If the investee company, when it comes to the legal documentation phase, tries to negotiate out terms that were agreed at term sheet stage, it can be very difficult, and it actually can cause a deal to fall over potentially with an investor. They could potentially walk away because they've absolutely no obligation to consummate a transaction based on the term sheet. Aside from the principal transaction document, so as I said, subscription agreement, shareholders agreement, convertible loan note instrument, there's a whole heap of ancillary transaction documents, and they range from board minutes of the company to approve the entry into the relevant documents, or the entry into the loan note instrument. If there's board appointments or observer appointments and things like that, they should be covered in the board minutes. If there's an allotment of shares, they would be covered in the board minutes as well, and the board would instruct the company secretary to file the relevant company's office filings. In addition to the minutes, to the extent that the constitution of the company needs to be updated to reflect agreed commercials, a shareholders resolution would be required, and company's office filings would need to be attended to. So essentially, the constitution of the company would need to dovetail and absolutely not conflict with the provisions of any shareholders agreement that's entered into. Aside from that, there will be the disclosure letter, which will come to in due course, which discloses exceptions to the warranties as provided for in the agreement, and we'll detail that in a minute. Final documents then will be the likes of share certificates, loan note certificates, and ultimately the preparation of a transaction Bible. It's key to always have one eye on a future funding round. So what we always suggest to our clients is, on completion of a funding round, prep the Bible, add it to your own kind of online or cloud database, such that when it comes to the follow-on funding round, all relevant documents relating to shareholders' rights that have been granted historically are very readily available. It expedites due diligence on a follow-on round, and it's massively in the founder's best interest. It'll save them a lot of headaches trying to scramble around for historically executed documents that may or may not have been scanned up. Moving on then just to the next section then, aside from the principal transaction documents, it's more kind of certain kind of matters that flow from the principal transaction documents, and just pass you across to Michael just to give you a general overview on warranties, covenants, and on the odd occasion indemnities and who provides them.
Thanks. So these would usually appear in either the subscription agreement or the investment agreement. And they're essentially ways for the investor to either protect themselves or reduce the riskiness of the investment. Warranties are essentially contractual promises. They're statements of fact about the business. So one example would be there's no litigation against the company. They're provided by the company and the founders to the investor. The company and the founders obviously have working knowledge of the business. They know what's going on or what's coming down the track. The investor doesn't. They will have done their due diligence, but this is separate. That just gives them the information they need to know whether they'll make the investment or not. The warranties are contractual promises. So you will basically be signing the documents with a suite of warranties, similar to there's no litigation against the company. And that's a promise. If that turns out to be untrue, and there is litigation there, and it does result in a claim against the company, and the company has to pay it out, then the value of the company will probably be reduced, and the investor will take a claim for breach of warranty on that basis. So it's very important that the warranties are accurate and true. They're not unlimited, so the liability isn't uncapped. We go through that with you go through it with your solicitors when you're signing up the documents. It's typically capped at the value of the investment, or if the founders are to be liable, capped at 1 year's salary. And there's also a disclosure process where you can actually disclose anything that's inconsistent. So if you tell the investor that there is litigation and you give them full details of it so that they're able to appreciate it, what it might mean, then they can't later take a claim against you. And that's done by way of the disclosure letter, which will set out any disclosures, which Alan went through or touched on there earlier. Covenants then. A covenant is a promise to do or not do something. Where you'll most likely see this on an investment transaction is what are called restrictive covenants. They're essentially non-competes. So again, the investor doesn't want to put money into the company, and then the founders, who are really the driving force, have all the knowledge, all of the connections and the relationships. They don't want them to go off and set up just another business. So what you'll agree is that you won't compete with the business. You won't look to take its employees or its customers or its suppliers. And that's usually for up to, say, 18 to 24 months after you leave the business. So again, it protects the company and it protects their investment in the company. The final one then is indemnity. So an indemnity is a promise to reimburse the investor in relation to a particular liability. These would be fairly unusual in an investment transaction. It really depends what comes up in due diligence. If there's a specific issue that the investor is worried about that might give rise to a claim, they might look for an indemnity. So if the claim is brought and there's a loss in value of their investment, that they'll be able to recover that from you. That covers the warranties, the covenants, and the indemnities. Next then is disclosure. This relates to the warranties that I touched on. So you'll have a series of statements of fact, and you'll be able to disclose against them. And the more you disclose, actually, the better. So again, if we go back to there's no litigation against the company, if there happens to be a litigation, and it might be minor, obviously the investor wants to make sure they don't put money in and ultimately the money is just paid out to someone who's taken a claim, and it doesn't actually develop the business, then it doesn't increase the value of the company and their investments. So by disclosing, it gives you an opportunity to actually fill them in on everything that's inconsistent with the warranties. And once it's fair and accurate and full, and they can appreciate what it means, then they're making their investments, with their eyes open, and they won't later be able to take a claim against the company. So this is a process that we'd run through with clients as part of the investment. That brings us on to then reverse vesting.
Thanks, Michael. Okay, reverse vesting can be a contentious one. It's an area that's kind of,
Alan?
Yeah, look, exactly. That's the first point I have here. What is reverse vesting?
Okay.
Basically, it's a concept that the founder's ownership of the company or ownership of the equity in the company is earned over time, akin to a salary. So essentially on incorporation, the founder or founders would own the entire issued share capital of the company. So they own 100% of the company. As investments come in, they get diluted over time. They'll still, for quite a few years to come and a few rounds to come, they'll still hopefully maintain a majority ownership stake in the company. I know Michael touched on due diligence and disclosure there, but ultimately what is key to an investor is the founders being incentivized to stay with the business of the company for the duration of the life cycle. So say, for example, if the company's business plan says, right, we have a 4-year exit plan or a 5-year exit plan from incorporation. Here's the key team members. Each of those key team members holds, say, 33%. If there's 33% each. If one of those key members decides to leave, and it happens quite often because certain founders have certain personal needs, such as they might need to make a mortgage application and have to revert to a 9-to-5 job with a guaranteed salary and can't, go down the founder path, shall we say, and have a more of a leap of faith as to a return on an exit. So what happens quite often is the investors will seek to kind of get a level of comfort that if one or more of the founders leaves, that if they exit, they shouldn't be able to be in a position to just sit on the cap table and reap the rewards of the endeavor of the other co-founders. Mm-hmm. And it's one where it's the genesis, or it's based in one where it's both to protect the investor from their investment, but also to protect the founders as well and the company. So essentially what it allows is that the shares held by the founders would vest over an agreed period of time. The vesting period differs depending on the stage that the company's at. So let's give an example here. If a company is a newly incorporated entity, the reality is if it's an angel, friends and family raise, typically reverse vesting isn't an issue because the quantum of the investment is low, the valuation is low, the trust is there. But if you move on to an angel raise or a VC raise, we would see reverse vesting being included about 70% of the time on those sort of transactions.
And what does it mean? Does it mean then that if I'm a founder, 30% share in the company, and I decide to leave, those shares have to go back to the company?
Typically, but there's a couple of different factors here.
Okay.
So say, for example, the company's been trading for 2 years. There would typically be an acknowledgement by the investors coming in that a certain portion of the shares are banked, i.e. are not subject to vesting or clawback. Okay. So typically speaking, some investors look for 48 months, some look for 60 months vesting. We would typically try and negotiate down to maybe 36 months vesting, but also it wouldn't be 100% of the shares that are subject to vesting. It would be maybe between 50 and 75% of the shares that will be subject to vesting. That vesting, it's not just on a time basis. It depends on how the leaver actually leaves as well. Okay. So that comes down to the definition of between it. There's typically 2 principal heads, mm-hmm. Good leaver and bad leaver.
Okay.
So good leaver would be where a leaver leaves it in a way that there's no wrongdoing by the founder, such as, God forbid, they died were permanently incapacitated, were retiring, which is unlikely in an early stage tech company. If they were unfairly dismissed would be another example. So typically if somebody leaves as a good leaver,
Mm-hmm.
so they would be allowed to retain the portion of the shares that had vested, and the unvested portion of their shares would be subject to clawback for nominal value of the shares. Okay, so if they're 1 cent shares, they get 1 cent per share, and they would be clawed back by the company. So then essentially they're available for redistribution in the event that, say for example, the CTO is one of the co-founders and needs to leave, and ultimately you need to free up some equity to entice in a replacement CTO.
Yeah.
In the event that a founder is a bad leaver, so bad is typically, you can define good, and anything that doesn't fall within good results in being a bad leaver. So it's normally committing a breach of an agreement, fraud, wrongdoing, breach of a non-compete, something along those lines. Typically speaking, in the event that a leaver is a bad leaver, both the vested and unvested portion of their shares are clawed back for nominal value.
So all this is decided in this period. It's all decided prior to the investment going in.
Yeah, typically speaking. So if it's a friends and family or an angel raise, they mightn't get into the weeds, or they mightn't even provide for it. But you know, a serial entrepreneur that has seen founders exit early and leave a company high and dry will insist on leaver provisions being included. Typically the term sheet might make provision and say customary leaver provisions shall be included in the transaction documents. And that's where it can become a bit contentious when it comes to negotiation in the formal legals. If you look at it, a VC will typically expressly detail the actual applicable leaver provisions. So you typically negotiate what equals a good leaver, what equals a bad leaver at the time of negotiation of term sheet. And then it's essentially folded into the subscription and shareholders agreement, and to the extent required, reflected in the constitution. Look, from a founder's perspective, in light of the fact that it benefits both the investor and the company, and it helps protect the founders from their own co-founders, it's a bit of invariably there's a level of negotiation there. But what we try and do is to try and advise our clients to make sure that they keep the vesting period as short as is reasonably possible, you know, with one eye on the kind of the stage of the life cycle of the company. So if the company is a year out of the box, newly incorporated, then the vesting period might be slightly bit longer, because you want people to buy in for longer to make sure that they're there for the purpose of a follow-on raise. And also it's a difficult narrative to say, well, look, one of our co-founders has left. It's kind of, well, why have they left? What's the issue here? So it's increased queries on due diligence. So you ultimately want to incentivize the founders to stay for the course, to build the value in the business, to scale it per the business plan. What we also advise our clients on is making sure that the vesting period is monthly, as opposed to quarterly or yearly vesting, because that can lead to there being certain cliffs. So if you have a founder that wants to leave, they might say, well, I have a tranche of shares that will vest in the next quarter or at the end of this year. They kind of hang around like a bad smell. If they want to leave, you want to make sure that they leave in an orderly fashion and as soon as possible, because they won't be focused on the business, and you want to kind of go out to market and look to get a replacement founder in, or replacement co-founder. Last point, just on reverse vesting as well, and this is one that's often raised or queried by founders as well. What happens if we exit before the vesting period has run its course? And it's fundamental that the terms of the vesting provisions provide for acceleration in the event of a sale. So say, for example, you close an investment today. There's a 4-year vesting term. The company is sold after year 3. You don't want 3/4 of your shares having vested and the balancing quarter not vesting. So you'd make specific provision in the legals that in the event of an exit prior to the completion of the vesting period, there's automatic acceleration of the vesting. So they get the full benefit of all the shares that they hold on, you know, a fully diluted basis, shall we say, as part of an exit. look, it's one where reverse vesting can be contentious. Half of it's born out of ignorance on both investor side and founder side. But as long as the terms are within certain reasonable parameters, we generally have no issue with reverse vesting being negotiated and included in investment documents, because it is, as I said, good for the company, or good for the goose and good for the gander here.
There's a question, Alan. This is really helpful, I think, and probably, it is, you're kind of helping us anticipate all of the detail that's required at that stage. So we have a couple of questions from participants, and I'd say it's in line with it. It's probably a lot to take in for somebody who hasn't gone through the process. So a participant has asked, what other websites or books do you recommend to read up on the different forms of investment? And she says, I'm in the early beginning of building a brand. So she'd like to get her head around the system here in Ireland. And so would you have any recommendations on, you probably don't have any cause for for a need for those, easy little manuals, but do you know of any that people might use?
Yeah, it's more of one where there are certain kind of seed legals, or a startup lawyer, or there's lots of resources out there. A lot of them are more kind of US or European centric than Irish.
Yeah.
Like Enterprise Ireland's website, for example, doesn't go into any detail relating to kind of seed raises or non-EI raises. But the systems are still very similar in the US, the UK. There's like a general Google, and I know, that might sound a bit general here, but Google is a friend on this. So like, say, for example, if someone's looking for more information to get kind of more of a detailed narrative on reverse vesting, there's so many blogs from startups or entrepreneurs that have been through the process. They'll detail their lessons learned, things they did right, what they do again, what they'd absolutely avoid, what sort of investors they'd avoid. But like what we normally do once, say, term sheet lands, or a draft term sheet might land from an investor, or an early stage company's looking to kind of compile its own term sheet to issue to friends and family. We'd run through the terms and the common pitfalls at that point in time.
Okay, so you give us guidelines, you give us guidance on what to include in that term sheet.
Absolutely. Look, there's any experienced investor will look for certain customary terms. It's just within certain parameters they can be agreed, and then it's just one where, if an investor has a long shopping list, it will be one that you'd say, well, look, these are completely off market. They'll actually end up scuppering a follow-on raise because they will have too many rights at too early a stage. And it comes to, some of the points that we're going to raise further on in the slide. It's making sure that investors don't have evergreen rights. So what I mean by that is, if an investor is the only show in town, you can only secure one investor. Essentially, if you negotiate too hard, they'll walk away. So some provisions that you'd prefer not to give, or some rights you'd prefer not to give, you might have to soak up for a period of time. That period of time would typically be linked to a percentage shareholding that they have in the company. If, for example, you have a follow-on raise and an investor dilutes down, then some of those rights that they have should automatically dissolve. So these are kind of key things that we build into the term sheet, but depending on how they're actually built in would depend on the type of term sheet that, be it VC, angel, friends and family. Lots of these things, they're not even raised at friends and family stage or real early seed stage, but VC stage and follow on, it's fairly contentious.
Okay, so just then to close out that question, you don't have any specific handbook or resource to look at? But
what I'm more than happy to do, Rose, is send on a few links of a couple of really, really helpful blogs and just kind of narratives. But
that would be really helpful.
A lot of it's more UK based, but very similar considerations applied there as here. While they don't have Enterprise Ireland, they'd have other similar support structures. But from a seed level, so an angel raise and below, there'd be lots of available resources online.
Okay, what we'll do also is we're recording this session, and then we'll be converting this in, and we'll share the recording with anybody who's registered. And then we'll also be converting this narrative into a blog post. So what we'll do is, when we have those additional links through from you, Alan, we'll incorporate those into the blog. And because I think, practically speaking, when we go to a firm like yours, in any case, you're going to take care of all of this for us. As founders, we don't need to know this level of detail, but we do want to know what to expect, don't we? And to what to kind of look for. So we'd be in good hands, but we want to know what we're getting into.
Absolutely, Rose. Look, it's one where we see quite a few founders that come to us after they've executed a term sheet, and then it's too late.
Okay.
Because it's very difficult, as I mentioned earlier, to negotiate back from what's been a commercially agreed at term sheet stage, and then when it's actually dropped into the formal legals and you try and negotiate it out, it's actually, it builds a lot of bad blood between the investor.
So start with a good term sheet. Yeah.
Exactly.
Okay.
And look, those links and the kind of resources that are available on the World Wide Web, they'll help educate the founder to ask the right questions of us as well. But typically speaking, when we would get a term sheet, we would revise it to bring it in line with what we would see in the market. But it's always good for the founders to, I guess, educate themselves so they know exactly the impact of us revising reverse vesting provision and the percentages, the impact of us changing a definition of a good lever and bad lever, etc. So, but
I have another question also, Alan. Then is what happens if you're located here in Ireland and you get an international investor on board? I suppose the question is, do the same, processes apply?
Yeah, they do. Typically speaking, like we deal with a lot of US and European and UK investors, some kind of further afield as well. What's important is to ensure that the investment documents are governed by Irish law and subject to the jurisdiction of the courts of Ireland in the event of a dispute. Those foreign investors will typically, depending on investment size, they'll typically engage local counsel, so an Irish law firm, to advise them on their Irish investment to make sure that everything is in order from their perspective, from an Irish legal perspective. If the investor, for example, is from the UK, and we would deal with a lot of UK investors and various investment funds that have invested and are currently exploring investments in our Irish clients, and sometimes they will have dual qualified lawyers in the UK, so they can practice in Ireland and the UK, and they won't bother engaging local counsel here. But it's absolutely no impediment. If anything, non-Irish VCs are more light touch than the Irish VCs in the market. So when I say Irish VCs, Rose, what I mean is the likes of Kernel, Shore Valley, Atlantic Bridge, Delta, Frontline, where there's a limited pool of VC investors in Ireland, and they all have very similar shopping lists when it comes to the legal provisions. Whereas when you have a US investor, they might have deeper pockets, so they're more light touch on the legals. It's likewise with UK investors. They might be from a bigger fund or a bigger investment fund, so they've less asks. So that's just something we're considering from the founder's perspective, is don't be stuck looking at Irish VCs for investment. Look further afield. Quite often they because of their deeper pockets, they can afford to take a bigger punt, i.e. a bigger investment size, and quite often the legals can progress pretty quickly.
Okay, thank you.
Okay, just moving on to the next one there, that's can be contentious, but it's more as the company scales that it becomes contentious after completing a number of funding rounds at kind of early stage. It's less so an issue if it's structured accordingly at the outset. And I'll pass you on to Michael just to discuss board composition.
Thanks, Alan. So the board manages the company day to day. when you set up the company, typically the directors are either all of the founders or at least one of the founders. Depending on who the investor is, they might look for a board appointment right. It gives them some visibility and a say at board level. So if it's friends and family or an angel, probably won't look for it. Depending on the size of the investments. If an angel is, making multiple investments, and it's a large investment, then maybe they will. Versus when you come to a VC investment, they almost always will want a board appointment right. They might not look to go on the board immediately, but they'll have the right to appoint a director if they choose. You'd usually have the founders as the major shareholders still. So they would tend to control the board. And one thing just to watch out for, as Alan mentioned earlier, is just not to have these evergreen rights. So, the director appointment right just stays forever regardless. It should be linked to a percentage shareholding in the company so that, for as long as, say, you hold 5% of the shares in the company, you're entitled to appoint a director. But if you get diluted down then on future rounds, another VC comes in at a later stage, they might want a board appointment right as well. So you don't want the board getting unwieldy with too many people on it. The first board appointment right would tend to fall away unless they also invest. They follow on with their investments and increase their stake in the company. Essentially what you're trying to do is make sure that someone who doesn't have a very, very small shareholding also has somebody on the board as well. Board composition is definitely something to agree at term sheet stage, and it's just reflected then in the documents, in the transaction documents when they're negotiated. So I think that's it from us then, unless there's any questions. Or Alan, sorry,
I've kind of just one more, Michael, that I just wanted to touch on. It was just investor rights, so vetoes, consents, and reserve matters. It's just one of these contentious items, or can be contentious, that we said we throw it into the slide deck here. But essentially, going back to kind of what I said at the outset, at Alan Corporation, the founders will be the majority shareholders, or they'll own the entire issued share capital of the company. An investor, when they come in, will be a minority shareholder. Under Irish company law, majority rules. So basically, the majority can pretty much do whatever they want within reason, unless they're subject to contractual restrictions. And the contractual restrictions in investment documents typically come in the form of investor vetoes or investor consent items. So essentially what these are, and they'll be included in pretty much every investment document from angel right through EI, family offices, VCs. On occasion, they're in friends and family transaction documents as well, but they'd be pretty light touch. It might be half a dozen veto items, whereas in a kind of a more formal follow-on raise, there could be a whole suite of 30 to 40 reserve matter items. So essentially what these are a restriction on the company carrying out certain material items that are outside the ordinary course of business without the consent of the investor. So it's not linked to their shareholding. It protects them as a minority shareholder because they could be outvoted at board level, because the board would be controlled by the founders. And it'd also be outvoted at shareholder level because the founders would typically be able to approve any ordinary resolutions, which are 50% plus, or special resolutions being 75% plus, without the investor having to consent. Key on these is that, as Michael touched on with board composition, it's that they're not evergreen. So if you have an investor coming in and say, for example, post their investment, they hold 10% of the company, and they have a shopping list of veto rights. If, for example, they're diluted out on a follow-on round, those veto rights should also dissolve or, I suppose, reduce accordingly. So you shouldn't have, for so long as an investor holds shares in the capital of the company, they get all these rights. It should be for so long as they hold shares representing not less than X% of the company that they have the veto rights. Also, it's important to kind of make sure that the relevant thresholds, so lots of these veto rights will call out thresholds. So I'll give you a couple of examples. There might be hiring employees on a remuneration above, say, €75,000. That would be outside the ordinary course of business. If you set that threshold at €25,000, you would technically you'd have to go on to the investor and get their approval to hire, an admin staff member, for example, which that's not what it's intended. It's more to capture material outside of the ordinary course business transactions that would have a material impact on the business, which would also have a material impact on the underlying value or not of the investor's investment or share value. So look, it's one, I think the key takeaway word here today maybe should be evergreen. Just try and avoid evergreen rights where possible, particularly at an early stage, because you have to have one eye on a follow-on raise. And if an investor has an evergreen right, you have to come to them with a begging bowl to try to get them to soften those evergreen rights for the benefit of the overall shareholder pool or the follow-on investors. So my takeaway word of the day is evergreen here. Any questions, Rose?
That is all the questions we have so far. If people would like to pop any questions quickly into the chat, otherwise you may have answered everybody's queries so far. That seemed really comprehensive to me anyway. So you have your contact details there, Alan and Michael, for people to get in touch with you directly. And yeah, no more questions coming in. So I think unless you have anything else you'd like us to counsel us on, we head into this.
Well, look, Rose, for the benefit of people on the call, feel free to reach out, on a no obligations basis, to just, no questions too stupid, as they say. We're here to kind of answer any queries that people will have, to kind of try and avoid common pitfalls as they negotiate their term sheets over the coming weeks, months, and maybe years. That's what we're here for. Like, we advise companies from early stage right through to exit. So, if we haven't seen it, it's not there. Like, we've come across so many different items. We probably have come across the investors that are investing, so we'll know their kind of squeeze points or pressure points, or how far you can push them before they'll actually walk away. So feel free to reach out to us. Details below. Have a look at our website and see kind of some of the clients that we've acted for and currently act for, to kind of give you a level of flavor of our experience in the space.
Brilliant. Well, look, thank you very much to both of you again. And as I say, anybody who's registered for today's webinar will send out this recording, and we'll convert this into a blog document so that people can at least, I suppose, have an overview of what to expect even before they approach you. But thank you very much to both of you, and we'll see you again soon.
Thanks, Rose. Appreciate it.
And for anybody who's joined us today, we have lots of really interesting webinars coming up. One, we had just a comment asking for some advice today on getting investor ready or making a pitch to investors. And I said that is outside of the scope of today's webinar, but we do have a webinar scheduled for the 1st of October, which is presented by Dublin BIC, and that is about getting investor ready. So if you're at that stage, that's a really helpful webinar to sign up to. And then our next week, we'll be talking about pensions. So hopefully there's something in there for all of you. And thank you very much again for joining us. Have a great weekend, everybody.
Thanks, Rose.
Bye.
Thanks, Rose. Bye-bye.